Okay, I think that's probably about it for participation. Anyone feeling left out? Okay, let me close the public portion of this. And yes, Ms. Trott.
I have a specific question of Mr. Porter, if I may. I am not aware of the rules and regulations of Conessa Park Homeowners Association. I suspect that we would not be, but isn't our responsibility to determine whether or not this particular application meets or satisfies the requirements that's been set by Princeton when it pertains to subdivision? That is our only responsibility here. Is that true?
Yes.
Thank you.
Which are?
Does it comply with the zoning?
I mean, does it advance the zoning goals of the neighborhood, and is it?
Does it meet the standards? Issues of, I mean, we've heard a lot of things that, in my judgment, are not relevant tonight. We have a staff here. Mr. Bridger is the zoning officer. We have a representative from the engineering department. All of our, and Mr. Solo from the planning department. All of our reports are that this complies with all of the municipal standards for subdivision. And that's our chore. That's our goal. We're not looking at what's good for the neighborhood, whether the Scaviers have a financial problem or not. That's not our issue. They can spend the summer in Long Island. They can go wherever they want. They don't need to have to agree to have a reverse mortgage. Those financial issues are totally irrelevant, and to the extent that they were brought up, they're irrelevant. In my judgment, all of the testimony about the applicant, the release that the applicant has, that's also irrelevant. Just by hearing what you've heard tonight, this board is not equipped to determine whether a signature on that petition, which has been purported to be withdrawn, Mr. Libertazzo's testimony, we're just not prepared to decide whether that's a valid issue or not. Other issues of whether someone misunderstood or was prevailed upon or felt prevailed upon, that's just not an issue we can decide or equipped to decide. That's what courts are for, to decide contested issues. We talk about lawsuits. In my judgment, if we were to deny this application because of the Carnassa Park restrictions, we'd be very vulnerable to a lawsuit. That's not our role. The law is clear. Of course, you understand that the neighborhood has its views and it has its mechanism for protecting those and for enforcing those. But the issue, I think it was said, whether it's we have no reason to believe the restrictions are invalid. But if the applicant felt that they were not valid, that's something the applicant could contest in court, just as the neighbors could withdraw or purport to withdraw their consents. So in terms of what the question was, what are we doing here? What we're doing here is we're deciding whether this proposed application meets the standards that were enacted by Princeton. And our staff tells us they meet or exceed, these lots meet or exceed the requirements.
Alan, I think one thing that we can do is, and correct me if I'm wrong, is discuss a more permanent arrangement for the path that the school children use to get to Littlebrook School. We heard from several neighbors who'd like a more permanent arrangement than just the letter of agreement or memorandum of understanding. That's within our purview to ask that be a condition for approval, is it?
While Alan's thinking.
Well, I'm not thinking, I'm just thinking of how to respond. I think
You can just say yes or no.
No.
let's see whether, I mean, this is really, the fact that there's even a license agreement is the voluntary action of the landowner. So the landowner has taken it to one point. The question I guess we would put to the applicant is the applicant willing to consider a permanent location?
10 seconds.
And to make that rather than a revocable license.
But could you answer the question?
Yeah, you want me to answer whether we, as a matter of law, have the power to require a private landowner to impose a permanent easement on the property for the benefit of others when it's not generated by the subdivision? No.
Okay. So
We certainly can request it.
they volunteered to work with the town in 2010, and in discussions with Reverend Scavere and Mrs. Scavere just now, they're prepared to make it a permanent easement, as my friend Grayson Barber would like to do on her property, so that there would be a permanent easement. I think I'd like for it to be characterized as this meandering location, that green line, red line, the location to be determined with the staff to make sure that it's acceptable to the person who builds a house on the new lot as well. But there's a willingness to make it permanent.
Yes.
Well, thank you for that. I had another question about the covenant, and I understand that that is supposed to be irrelevant to our decision, and my question is the converse true? So is any action by the board irrelevant to when a court, if it sounds like that's where this is headed, in terms of how a court interprets the covenant, our action will be irrelevant to that decision?
Definitely, and we can put in the resolution of approval, if there is one, that this shall have no binding or should have no effect on any court decision relating to the private restrictions.
The applicant quite agrees, and I put back up Mr. Cox, who says the grant of the variance in no way affects the validity of the covenant, nor the covenant the validity of the grant. So according to the expert that we all look to in New Jersey,
to Mr. Cox?
we would agree that we don't think there's any relationship between the two.
Ms. Holman?
Yeah, I wondered why the subdivision committee had referred this to the whole board and not made the decision, not having been at the meeting. I looked at the conformance with zoning, and it looked fine. I think I now understand a bit more about the psychology of all of us, and we're all members of the community, and we're always greatly influenced by how neighbors feel about a property. And I've never been to a subdivision meeting here or anyplace else where the neighbors said terrific. I mean, it's not going to happen. But and that's why I asked the question at the beginning, I mean, let's take the deed restrictions off the table. It's just not part of what we're talking about. I do think that in every way, legally, the zoning, which is our council's determination, allows this to happen. in terms of all of the criteria that the two properties would involve. And I can't, other than the path, which has become a tradition, and I think I can well understand the usefulness of being able to go through it. I cannot see why we would not find this consistent with our municipal zoning.
David?
Just a minor comment in response to one of the public comments, the concern that the 1 acre lot would be re-subdividable by a developer in the future. The fact is that there's a 100-foot lot width requirement in this zone. The 1 acre lot is only 187 feet wide, so they would need a variance, which I'm quite sure would be denied if a developer were to try to subdivide that 1 acre lot.
Thank you.
They'd also need the approval from the Carnassa Park Housing Board.
And lots of time to do all of it. Yes, Ms. Corona?
Well, so I'm going to ask a question that I get asked all the time, and that's what you've essentially said is we have zero reason, ability to say no legally to this application.
On the record presented, that's correct.
So why do we have this hearing? I mean, this is what everyone asks me all the time, and I kind of want to know.
Actually, this is a sequence of hearings. It went to subdivision, and subdivision has to be unanimous, and it was not. So
But why did it go to the subdivision committee?
Because there is a process under the land use law for subdivisions to get public approval, not just staff approval.
But is there would there be any legal way for the subdivision committee to say no?
No, and so that's why we have a minor subdivision committee meeting, committee to screen the applications before they come here when the board has no ability to say no. But it requires a certain vote, and it didn't receive that vote, so it did come here.
And I'll answer for you.
Well, I also have, I'm not finished. Sorry.
But I mean, the subdivision committee felt that that there should be a public airing of the things you heard tonight, and that's what
there were as the person who voted no at the subcommittee, at the subdivision committee, I would say my concerns were twofold. One was about the path, and one was about the noticing for the subdivision committee meeting itself. There were neighbors who claimed and were concerned that it wasn't noticed properly, that the meeting itself wasn't noticed properly, and that's why I voted against, because I felt like the neighbors deserved a chance to come before some committee properly noticed or some board and have their say. So if you want to throw me under the bus for the one who's keeping us here until 10 after 11,
no, that's not my intent
this is
at
the
all.
reason why, because I felt that everyone in the neighborhood had the right to be heard, and not just a small group of neighbors at a meeting at 10:30 in the morning on a weekday.
But, I mean, the reason that I'm asking this is because I feel like while we're the planning board, we're also community members, and we're hearing from this whole community that that the community has made covenants amongst themselves, which to me seem very important, and I feel uncomfortable approving this and helping kind of fracture this neighborhood. I mean, I wonder if we could let the covenant issue resolve itself and then come back.
That's
I just can't buy that. I don't think that is our job. I mean, as council people, you probably are more influenced by the emotions of a thing like this. But we just have a simple job here tonight, and that's to decide whether the zoning that you as council members have approved and could change if you don't like it, is being met by this application. That's a very simple thing, and it has nothing to do with who you like, who you don't like, and it simply is a matter of interpreting our own ordinances. And I do think that we have given the neighbors full opportunity to talk about something that we have no responsibility for. They know that, they heard that, and they wanted to be heard, and they were heard. But we still have an obligation to do what we're here for, which is to decide a project on the basis of the law. And so I am ready to move for the approval of this minor subdivision, along with the various conditions or requirements that have been put in, the idea that the path, we all have a strong feeling that it should be made permanent, but we have to wait, and I do think you have DEP issues and others, but that's would be a high consideration of mine too. About the trees, I don't know. I think we have a very rigorous tree ordinance now that ought to be relevant.
But they agreed to protect the trees in the side yard setback. So
Yeah, so I think that basically, I'm ready to make that motion.
Well, but I wanted to know if it was an option. I mean, would that be a legal option for us to base our approval on the
the
covenants?
deadline for action is tomorrow, Jenny.
Pardon?
The deadline for action by this board is tomorrow,
Yeah.
10/7/16.
May
I'm
I,
asking Alan.
may I second
I'm
that
sorry,
motion
we have a
so we can now
a second
discuss
to
it? I second.
I just want to clarify what's in, can we also have some language in there that reiterates just on the record that we acknowledge that there's a dispute over the covenant and that our decision is separate from that? Just, I mean, it was in our documentation too, but if we can have some language that says that, I think that would help address
Sure.
those of
I
us who
said
feel
before, we
uncomfortable.
certainly can put in an approval resolution that this approval has no effect on the private restriction.
Okay.
And in terms of the conditions, there are, in addition to those in the report, there's the condition that the applicant will work with staff to locate a permanent location, or a location for a permanent easement for the pathway back for Locust, to the benefit of the Locust people, Locust Lane people, and that the trees, and I'll get the details on this, I guess within the 15-foot setback area will be preserved.
But could we put a condition that the covenant issue be resolved as a condition?
No. I mean, that's implicit, because their approval will be dependent on that issue being resolved if the Carnassa Housing Board feels that this is in violation and seeks to challenge the applicant, however whether it's the applicant who brings that action or the housing board, that issue, if it's in dispute, has a means of being a place to be resolved.
All right, we have a motion and a second. Is there any further discussion? Would you call the roll then, please?